The next doctrine that we have to address is the step transaction doctrine. And the easiest way, this is probably the easiest doctrine to understand. We are all sitting here in Brasilia, right? Let's assume we all want to go to Sao Paulo. But someone tells us that we can derive a benefit if we fly from Brasilia to Rio and then to Sao Paulo. We could just fly directly to Sao Paulo. That would be the most direct route. But if we fly to Rio and then fly from Rio to Sao Paulo, we get a tax benefit. So we all get on the plane and we all go to Rio to get our tax benefit before we go to Sao Paulo. If you take an indirect path in order to accomplish your objective, and the only reason you flew to Rio was for tax purposes, the government is going to ignore your trip to Rio. They're going to say, no, you flew directly from Brasilia to Sao Paulo, and you don't get your tax benefit. That is the step transaction doctrine. I think I'm going to skip ahead here a little bit. There are other doctrines in the U.S. law. They're not as important as the ones that we just covered, but there are many more doctrines to talk about. There's the conduit doctrine, there's the assignment of income doctrine, and there are more doctrines under U.S. common law. Now, before we go on, I want to talk very briefly about a fairly recent study that a professor in Illinois, the state that I'm from, conducted on this issue of common law doctrines. The professor looked at over 300 cases in the United States, and he looked to see how often these different doctrines were used, and he also looked to see who raised the doctrine. Was it the government? Was it the court? Was it the taxpayer? Who raised the doctrine? Interestingly, of those 300 cases, and this was over a 14-year period, the doctrine that was raised most often was the substance over form doctrine, which makes sense. It's the most important doctrine that we have. So that's not a very surprising result. What was very surprising was that the party that was most likely to raise the doctrine was the court. The court was the most likely to raise the doctrine, not the taxpayer, not the government. The second most likely person to raise the doctrine was the taxpayer. The third most likely to raise the doctrine was the government. And if you think about it, that makes sense. Because as I said at the beginning, the substance over form doctrine is not really it's not an anti-abuse doctrine. It's there for both taxpayers and for the government. What did the government raise most often? The doctrine that the government raised most often was the sham transaction doctrine. The doctrine that the government raised second most often was the substance over form doctrine. The doctrine that the government raised third most often was the economic substance doctrine. And the fourth most raised was the business purpose doctrine. And the last to be raised by the government was the step transaction doctrine. Now that ranking is important for what we're going to talk about next. Economic substance doctrine was not the most often raised doctrine by the government. It was third. Now, this year, on March 29th, 2010, our president, President Obama, signed the Healthcare and Education Reconciliation Act of 2010. This act sought to codify or bring into our statute the economic substance doctrine, only one of the doctrines that we talked about. All of the other doctrines still apply, okay? Now, if the doctrine applies, the provision states that a taxpayer must be able to show that he had a change in economic circumstances, so there's been a meaningful change in the economic relationship of the party, and that the taxpayer had a substantial non-tax business motivation for the transaction. So remember how I said earlier that where you litigated in the United States would potentially determine the outcome if you were litigating the economic substance doctrine? That is no longer the case. Every single state in the United States must now apply a two-part test. It's in the Internal Revenue Code. There's no ambiguity about it. Every single taxpayer has to satisfy both tests. Now, if the taxpayer fails to satisfy both tests, there is a penalty. The penalty, the size of the penalty, depends on whether or not you disclose the transaction. If you disclose the transaction, you are subject to a 20% penalty. If you do not disclose the transaction, you're subject to a 40% penalty. Now, I have to tell you, as a practitioner, every taxpayer that I work with, and I work with quite a few, large multinationals, right now, the tendency out there among taxpayers is that no one is going to disclose. And the reason no one is going to disclose is because you don't get anything for it. If you disclose, you will certainly invite an audit from the U.S. Internal Revenue Service, and you will almost certainly get assessed, and then you got to go to court. If you don't disclose, the worst thing that happens is that the penalty goes up to 40%, but the Internal Revenue Service may not catch the transaction if you don't disclose it. So no one's disclosing. The big concern by taxpayers right now, and the government is under tremendous pressure right now to provide more guidance, because this provision has really changed the law in the United States. The government is under tremendous pressure to tell us when it's going to assert this doctrine and when it won't. Remember, I said a couple of minutes ago that over the last 14 years, the government did not raise the economic substance doctrine most often. It raised the sham transaction doctrine most often. Well, now think about it. If you're in the government and you have your choice of all these doctrines, which one are you going to raise? Are you going to raise the sham transaction doctrine, which doesn't carry a penalty? Or are you going to raise the economic substance doctrine and scare the hell out of the taxpayer? You're going to choose the latter. That's the fear. And so the government right now is under a lot of pressure to tell us when it plans on asserting this doctrine. And thus far, they haven't indicated when they will and they won't. So that's the U.S. experience. I just want to leave you with a couple of thoughts, and maybe it informs your decision as to how to craft your rule. I think it's quite clear under the U.S. law, even though we have all these doctrines and we've got a lot of cases, it's pretty clear to taxpayers and to tax advisors that if you want to have your transaction respected, you have to have a meaningful change in economic relationships. There's got to be a difference between the situation before the transaction and the situation after the transaction. There's got to be a meaningful change. It's also pretty clear to people that they need some sort of non-tax motive for doing the transaction. You can't do something solely for tax purposes and expect that it's going to be respected. Those concepts are pretty clear in the U.S. law. Some questions that are not very clear are listed on this slide. For example, should related party transactions be subject to more scrutiny than unrelated party transactions? Should they? Some courts say yes. Some courts say no. What constitutes a valid business purpose? Does the reduction of other countries' tax constitute a valid business purpose or not? What about a financial statement benefit? If I get a financial statement benefit by doing the transaction, is that a business purpose? How significant does the business purpose need to be? Does it need to be bigger than the tax avoidance purpose? Does it just need to be substantial? If it needs to be substantial, how substantial should it be? These are the questions that we wrestle with. One of the last questions that we wrestle with at the bottom of the slide is something that many courts have struggled with, and that is whether or not, when you're analyzing a transaction, you analyze every single step in the transaction. If you do a transaction that requires 5 different steps, does every single step need to have an independent, non-tax business reason? Or is it sufficient that the entire transaction have a business purpose? There's not really an answer to that question under U.S. law. Some courts would say you have to look at every single step. Other courts would say no, you just need an overall purpose for the entire transaction. So that's it.